Welcome to chapter number 6 of Professor Schaffner's book, and we are talking about legal issues in international transportation. And in this first video, we are talking about liability of international air carriers. This chapter is not only about air. This is only the first chapter. We will also talk about liability by sea and about the liability of ocean transportation intermediaries. Okay, let's start with the liability of international air carriers. So once the buyer and the seller, they have negotiated the contract, of course, the goods they have to get from point A to point B. And they can use air, marine, or land carrier, and they have to transport those goods. Normally, this sector is governed by a private contractual relationship, but in the international transportation law, we have a lot of uniformity because more than in other areas, because we have international conventions and treaties, and they help to harmonize the effect of national laws. So in this chapter, we will learn more about the liability of air carriers and for death or bodily injury to passengers on international flights, right? And also we will talk about the loss or damage to baggage and air cargo and the liability of marine carriers or transport intermediaries. Sometimes, and there are also some issues of insurance law. Okay, the background is that we have a high peril of the sea, right? So the perils of the sea means that the sea is dangerous for the goods, for the transportation. And yeah, we have some funny different, so the term is not defined everywhere the same. So in the United States, Canada, we have some special definition. For example, here, peril of sea, this must be of an extraordinary nature or arise from an irresistible force and overwhelming power and cannot be guarded against through ordinary prudence, right? This is, for example, the peril of sea. And UK and Australia, they have a different one. So at the end, we have some Hague rules, and they're trying to uniform the constructions of all this, of the peril of sea. Good, but first let's start with the liability of international air carriers. Aviation and maritime law rely heavily on international conventions, but we have here really a huge history, because a long time, right, that we see a cargo was shipped by ships. So maritime law grew out of customary law used for centuries, and there we have always one thing to limit the liability. But one of the first conventions are the Warsaw Convention from 1929. It has a lot of limitation of liability. For example, they limited the damage to cargo at about $10 per pound, or they had a personal injury limit, 75,000. And of course, this may exceed it if the airline is reckless, right? This is only the normal risk. Okay, so if a shipper wants protection, he must declare and pay higher value. This is very important. So this is only the normal liability. And if this is not enough, you must declare this, you must say this, but then of course you have to pay more. So this was the Warsaw Convention. The next convention is the Montreal Convention. It's from 1999, and it replaces the Warsaw Convention. And if it's ratified, for example, in the United States. The Montreal Convention only applies to passengers. And if they're ticketed for international travel, right, this is very important. And if you have if approved by all countries involved in the legs of the journey, of course, and will not have to, you must not have to prove the airline at fault in case of personal injury or death. Good. It's very important that these conventions that they're applicable to international carriage. So international carriage means from not only a local carriage, and we have a liability for all damages up to $152,000. So the carrier is liable for damages above that unless not due to its negligence or was the sole result of negligence or wrongful acts of third parties. And it's applicable to international carriage. The next case has to do with this question. Can a plaintiff, can somebody who suffered something on a flight, can they sue against the company, the air company? So in this case, it's all about a plaintiff's private action for assault and false imprisonment. So it's not damage, it's only assault and false imprisonment. And does this fall under the Warsaw Convention? And in this case, you will see it is excluded, it's precluded, right? This is an interesting case. If you ever have had a flight with El Al, I had a flight with El Al some years ago, and it's the security is so high because they're always afraid of some attacks, right, from terrorists. That means prior to boarding, I remember that time, there are always a lot of security guards and they're asking a lot of things, what you want to do and where are you going to fly and so on. And in this case, Tseng, they had to remove her shoes and lower her blue jeans to mid-hip, and a female guard was searched her body. Nothing happened, right? But later Tseng sued El Al in New York State Court for assault and false imprisonment. Okay, right? That was the judgment, but it's the judge. I mean, it's very important for the Warsaw Convention, because at that time we did not know exactly how is it applicable also on these cases. And of course, in this case, you can see this the decision. Just show this, it's written down there. So the decision of the Court of Appeals was reversed because under the Warsaw Convention, a passenger may not bring an action for personal injuries damages under state law when his or her claim does not satisfy the condition for liability under the convention. So it's only for other things, not only for damages you must have real damages. So not body injuries. On air, we have another liability for death or body injuries. So this is now in the Montreal Convention. And they have three elements for liability. You must suffer death or body injuries resulting from an accident, and it has to be on board the aircraft or while embarking or disembarking. And in this case, Olympic Airways, it's a very sad case, of course, the airline was liable for damages when asthmatic patient died from allergic reaction to secondhand smoke aboard on aircraft. So this Dr. Hansen, he suffered there, he died there because he was suffering from asthma and somebody was smoking on the plane. That was the days when we had part on the plane, certain part where you couldn't smoke and another part not, but actually everything was full of smoke, right? And at the trial, the court awarded to his wife 1.4 million judgment, but the company, the Olympic Airways, appealed to the Supreme Court and arguing that the death was the result of his internal reaction to the usual and expected operation of the airplane, and thus not a result of an accident. So there was not an accident. It was because he had his asthma, right? Okay, so you can read on your own what the argumentation here, and the decision at the end was the flight attendant's unexpected or unusual refusal to move the passengers to another seat, contrary to the airline policy and industry standard, was an accident. And if you have an accident, this is then external to the passenger within the meaning of Article 17 of the Montreal Convention. And because of this, they can get some money, right? Good. So, yeah. Okay, so they get the money. So in all these conventions, very important how to know what does it mean embarking and disembarking, because this is included in the liability. And a carrier is only responsible for accident that occurs on board the aircraft, or if they are embarking, disembarking. This is, of course, a factual question, right? Okay, in all these conventions, we have a lot of limitations on liability for death or bodily injuries. So the next thing is if you get money, normally you have here a liability system. So this has the special method to measure how much you will get, and they call this the special drawing rights, SDRs, and that means an airline is strictly liability for up to 113 SDRs, and if you have damages over these SDRs, then unless airline is presumed negligent for damages over, unless it can prove it was not negligent. So, and the convention does not specify what damages can be collected by a plaintiff. So it differs from case to case, right? Good. Sometimes we have also problems with cargo losses. That means the cargo is gone. Air carrier is also liable for damages sustained to cargo, but only under its control and only up to 19 SDRs per kilo. Can you see? And behind these SDRs, there's always an amount of US dollar, for example, and it differs from year to year. It changes, right? And you are liable, but only unless the shipper has declared a higher value on the wearable. And that's why it's so important that you take a look at the air wearables and the air cargo losses. It comes together because we have here the consignor and the consignee. They have to, especially the consignor, they have to fill in what is the value, right, of this shipped good. For baggage loss in this convention, Montreal Convention, we have a limited liability up to these a little bit about 1,000 SDRs for each passenger, right? Unless higher value is if you have signed it in the air viable or written in the air viable. There's some other things. Sometimes you have a damage because of delay or time limitations, especially for delay. So normally in this convention, the airline may be liable for delay up to around 4,600 SDR per passenger, so it's limited. And we have a time limitation. You can only come to court 2 years for legal action rights. And it counts from the date when the aircraft arrived or ought to have arrived at a destination. So this is an international convention, and in German, in the EU, we have different higher or more possibilities if you have a delay, right? So this is an international flight. Okay, that was all about liability on the international air carriers. In the next video, we'll talk about the maritime law. Thank you for your attention. See you soon.